It's Alan Bakke, central figure in a major civil rights case, returning to his home in Los Altos, California tonight after winning his fight to enter medical school.
I don't have any comment.
I think it's just a reflection of what life is like in the United States today. It's a reflection of 8 years of Richard Nixon and Gerald Ford, and it's a reflection of an American society which says we've given these people enough. They can sit in the front of the bus, they can sit downstairs in the movie theater, they can register to vote. Why aren't they happy with that?
This will bring the civil rights movement back into focus where the majority of Americans can support it, and that's going to be a real plus, I think, for the long term in this country.
My general view is that affirmative action has been enhanced. That's what I told the president, and he was pleased to know that.
Whether you lose 5-4, 8-1, or 7-0, when it's all said and done in the ninth inning, you've lost a great decision.
All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention.
Landmark Cases, C-SPAN's special history series, produced in partnership with the National Constitution Center, exploring the human stories and constitutional dramas behind 12 historic Supreme Court decisions.
Mr. Chief Justice, and may it please the Court.
Good evening and welcome to C-SPAN's Landmark Cases. Tonight, affirmative action. In 1978, the Supreme Court issued its first opinion on this issue in what's known as the Bakke case. The court's complex decision, the UC Davis Medical School's affirmative action program was declared unconstitutional, while the concept overall was deemed legal, has left the court and the country wrangling for decades over affirmative action. Two guests are here tonight who will help us understand the history and the legacy of this case. Both of them teach at Georgetown Law School, but with very differing legal philosophies. Let me introduce them to you. Neil Katyal was a former acting Solicitor General under President Obama. He argued 13 cases as Solicitor General and 37 cases on the court overall. He clerked for Justice Stephen Breyer, and he is today a partner at the Hogan Lovells law firm in D.C. Randy Barnett is also director of Georgetown Center for the Constitution, argued one important case before the Supreme Court, and is the author most recently of Our Republican Constitution, Securing the Liberty and Sovereignty of We the People, published in 2016. Well, gentlemen, in that opening historic newscast with Dan Rather, we heard two very divergent views of affirmative action, both its execution and its value for our society. What are your views as we get started here? Randy Barnett?
Well, I think that this case was a landmark case. It deserves to be in your landmark series because it basically set the agenda that we live in today. All the talk that we've heard about diversity, everyone who's grown up in the last 30, 40 years have heard about diversity and, on end. It never ends talking about diversity. Diversity comes from this case and Justice Powell's opinion when it became the rationale that allowed racial preferences to be used. And so we've been talking about diversity ever since this case.
Neil Katyal?
Well, first of all, it's a joy to be here with both of you on this all Georgetown panel. I agree with you entirely, Randy, and I'm not sure I'll be saying that all night, but right now, for what you just said, you're absolutely right. Bakke did set the terms of the debate and put the diversity rationale for affirmative action front and center. And the debates we've had ever since are all microcosms of what you just saw in that little run-up that was played in the clips.
This is a 14th Amendment case, so I'm going to remind our viewers here in our 12th and final program in this series of the 14th Amendment to the Constitution, which says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So what aspect of Bakke makes it a 14th Amendment case?
Well, it's considered to be an equal protection case because the allegation made by Alan Bakke was that he was denied the equal protection of the law by the Regents of California and the UC Davis Medical School because he was excluded from UC Davis Medical School on account of his race. And that made it an equal protection case under the cases that had come up to that point.
Neil Katyal, we're going to listen to our first piece of video of the program, and it's two justices in very narrow time frame, Justice Scalia in 2016 and Sotomayor in 2017, both talking about affirmative action, and then come back to you for your thoughts. Let's listen.
There are those who contend that it does not benefit African Americans to get them into the University of Texas where they do not do well, as opposed to having them go to a less advanced school, a slower track school where they do well. One of the briefs pointed out that most of the black scientists in this country don't come from schools like the University of Texas.
So they
come from lesser schools where they do not feel that they're being pushed ahead in classes that are too fast for them.
I was a law student. One of my dearest friends invited me to a law firm dinner. They were recruiting at the law school, and he introduced me as Sonia Sotomayor, a graduate of Princeton who had come from the South Bronx and was doing whatever I was doing at the time. And everybody got introduced, and the partner sitting across from me looks at me and said, "Did you get into Yale because of affirmative action?" He hadn't seen my resume yet. And I looked at him and I said, "It might have helped, but I also think graduating summa cum laude Phi Beta Kappa of Princeton with its highest academic honor had a little bit to do with it too."
Well, Justice Scalia was one of our leading lights on the judiciary, there's no doubt about that, but even he made mistakes, and I think he was roundly criticized for what he said in that oral argument, and criticized, I think, not just because it was factually wrong, but because it really misstated the true rationale for affirmative action, which comes back to what we're talking about today, the Bakke case, because in the Bakke case, the rationale for affirmative action that survived and that has become the template for affirmative action programs all over the country is not, oh, we're trying to benefit some minority. It's rather we're trying to benefit everyone through a diversity of experiences in the classroom and outside the classroom. And, it's that rationale that, conservative-funded litigation has tried to knock out for years and has never really done a particularly good job at getting rid of.
Well, Justice Scalia in that excerpt, it was not his finest moment in how he articulated the point. He was trying to articulate what's called the mismatch theory, which is that people need to be admitted to schools that they're more qualified for because they'll do better in those schools, they'll graduate more frequently, it'll actually be beneficial to everyone if they're matched. That's what he was trying to articulate. I thought the Sotomayor excerpt was kind of interesting because it suggested that she was a little sensitive about being characterized as an affirmative action admit. She said, well, it might have helped, so she didn't deny it, but on the other hand, she wanted to assert that that might not have been the major reason she was admitted, so why not? I think why not is the reason that Justice Thomas has said repeatedly in his opinions in this area, and that is there is a potential stigma attached to all minorities because some minorities are admitted under affirmative action programs that some will then say means they're less qualified. And I thought that she manifested a bit of sensitivity on that subject.
And as will athletes when they are condemned for, you got in because you play football or legacy admissions or so many other things. The idea that that should take off the table and make it, what we're talking about here is federal courts coming in and saying, you university, it's unconstitutional for you to do this. Even if you deeply believe it, we're taking it off the table. You can't do it. And, that's a nice policy debate that should be had at every university. Does it stigmatize or not? But the idea that somehow that this makes this unconstitutional, I think is a very tough argument.
And I agree with that. I think actually Neil and I are going to be agreeing about a lot tonight. And I do agree that that goes both for the mismatch theory that Justice Scalia was talking about and for this stigma idea that Justice Sotomayor was hinting at. These go to whether the policy is a good policy or not. They may or may not be relevant to whether the policy is constitutional or not, and we need to keep those two issues straight.
If you've been watching this series with us all along, one of the aspects of it that makes it so interesting is your questions. So we invite you to join us. We'll be going to calls in maybe 10 minutes or so. If you live in the Eastern or Central time zones, 202-748-8900. If you live in the Mountain or Pacific time zones or farther west, 202-748-8901. You can also send us a tweet, and if you tweet at C-SPAN, please use the hashtag landmark cases, and we'll mix your tweets into our conversation as well. Well, let's go to some of the roots of affirmative action. First of all, the definition of it. An active effort to improve the employment or educational opportunities of members of the minority groups and women, or to promote the rights or progress of other disadvantaged persons. That's just a dictionary definition, but now we'll learn more about the policy definitions of it. The first time we heard reference to it was in 1961 in an executive order from President Kennedy requiring affirmative action from government contractors to hire minorities. So what happened through the 60s and going forward with the government's interest in giving people a leg up because of their gender or their race?
Well, I'm old enough to remember, although I was kind of young in the 60s, but I'm old enough to remember that affirmative action actually had a somewhat different valence when it was first introduced into popular discourse. It was really about engaging in affirmative acts to go out and recruit people who had been previously excluded, because we all know that we tend to admit people that are like ourselves, and we tend to talk to the same people and recruit from the same places, and we should actually affirmatively, if we want to have an integrated society, we should affirmatively go out and identify qualified people and then make an effort to recruit them and hire them. That's what the affirmative action part meant. It didn't necessarily mean preferential treatment or differential standards. And it came to mean that, for better or for worse, it came to mean that, I think, more later on. But I think it's important to realize that you can engage in affirmative action without engaging in preferences. I mean, Neil was chair of the appointments committee that hired me at Georgetown. And it took some affirmative action on his part for that to happen, both to recruit me and to get me through the faculty.
One of my proudest moments at Georgetown.
And I will always be grateful for it. And I would count that as affirmative action on his part. So it's not to say that preferences are excluded as part of the package, only that affirmative action shouldn't be limited to preferences.
So there was one earlier case in 1974 that involving the University of Washington Law School, but the court did something called ruling it moot. What does that really mean? What happened there?
Mootness means that the case has gone away because of a change in circumstances, and it happens all the time. It happened to me this year in the travel ban case when I was bringing it to the Supreme Court the second time around. President Trump changed the travel ban a couple of weeks before the oral argument, and then his Solicitor General, his top lawyer, sent something in suggesting the case had basically gone away. It would have been moot, changed by circumstances, because it was a new one. And similarly here in this DeFunis case in 1974, the court said, you know, there's a change in circumstances. I believe the person had graduated or something, and so for that reason, the case has gone away. Court, you don't need to hear it. And I think one of the kind of fundamental lessons about the U.S. Supreme Court is that they don't ever, almost ever, have to do anything. And so they often do a lot by doing very little, by deciding not to do something. That itself is leaving the democratic conversation to unfold. And so in 1974, you have to understand this is a very rapid period of change at the U.S. Supreme Court and in society more generally. So just 2 decades before, you have Brown versus Board of Education, which defines really what the Warren Court is all about. And then from there, you have Warren coming off the court, replaced by Chief Justice Burger. And indeed, President Nixon nominates, just in his first 3 years of his term, 4 justices to the Supreme Court. So by 1974, you really have a change in the way the court, the composition of the court. And so it's not surprising when you have something like that sometimes the court's not going to necessarily going to get into a hot button issue until they really have to. And so by declaring the case moot, they let the conversation unfold. They let lower courts hear more of these. Here, this case, the Bakke case, was going on in the California state court system. There were other cases going on. That's a very common thing for the Supreme Court to do.
We always set the stage with the characters that you're going to hear throughout our 90 minutes. So here's the group you'll be hearing about. First of all, the Regents of the University of California, who are the governing body, of course, for the school. And in fact, they opened a new medical school at UC Davis in 1968. First class was all right. To remedy that, by the time the Bakke case came around, 16% of the seats had been set aside for special committee admission. Alan Bakke himself was at the time 35 years old, a former Marine Corps officer and an engineer who decided his calling was really medicine. He applied to other medical schools, Northwestern and University of Southern California among them, but was rejected because of his age. Justice Lewis Powell. What should people know about Lewis Powell?
Well, Lewis Powell was a man of the South, for one thing. And that actually was something that rankled Justice Thurgood Marshall a little bit during the deliberations on this particular case. So getting him to come around and essentially be the deciding vote on this case was actually a major accomplishment for the advocates of affirmative action.
Another important member of this cast tonight is Justice Thurgood Marshall. What should people know about him?
Well, probably the most legendary lawyer in 200 years. Maybe Daniel Webster can give him a run for his money, but that's about it. Created a litigation strategy that led to Brown versus Board of Education, became our first African-American Solicitor General, was a judge on the Second Circuit, a Court of Appeals in New York, and then our first, obviously, African-American justice on the Supreme Court, and a legendary heroic figure.
We visited the Library of Congress and their archives on legal matters. You're going to hear from Ryan Reft next, showing us a letter written to the NAACP from Justice Marshall. Let's watch.
So we are in the Madison building of the Library of Congress. What we have here is a collection of documents from a variety of papers, personal papers, and organizational records pertaining to Thurgood Marshall. This letter written by Thurgood Marshall to Miss Juanita E. Jackson, Special Assistant to the Secretary of NAACP, in July of 1936. The reason for this letter is to draw attention to his victory in Murray v. Pearson, which was a state appeals Maryland case, in which Donald Murray had applied to admission to Maryland Law School and had been denied, just as Thurgood Marshall had been denied years earlier. The role of the letter is to draw attention to the fact that Marshall had been working with Charles Hamilton Houston, who had trained him at Howard Law School, and they had been laying the groundwork for a kind of new approach to desegregation by dismantling segregation statute by statute. Law school, in particular, was one means to do that, and by working with Hamilton Houston and drawing the NAACP's attention to this issue, they hoped to, one, demonstrate that Marshall had gained a significant victory here, two, that this strategy for desegregation would be effective, and three, I think also Hamilton Houston's already working for the NAACP, and this is a means to maybe advertise Marshall's kind of bona fides and to draw him in later, which happens about a year or two later, and he becomes a central actor in these efforts.
So his own experience, background, and the cases that he'd been involved with all come to bear as he brings to the Bakke argument. Let's tell you a little bit more about Alan Bakke's credentials as he applied for medical school. He was number 468 out of 500 in the score on the admissions rating scale, 3.46 undergraduate GPA, and scored in the 97th percentile on the medical college admissions test. That was 72. UC Davis average was 69. He applied twice, and once in 1973 and again in 1974, and rejected both times. And the second rejection was what started the legal challenge. I want to ask about the age factor, though. So it sounds like he could have easily have pursued this on an age discrimination basis.
Well, this is before age was considered any kind of a suspect classification that could be challenged, or before there was any protective civil rights laws on the basis of age discrimination. And he was actually told by, not UC Davis, but by another law school that he interviewed with, another medical school, I'm probably going to make that mistake more than once, by another medical school that he interviewed with, that his age made it an uphill struggle for him to get admitted to that school. He had completed engineering school. He was actually supposed to be a first-rate engineer. He had done not only a Marine Corps, but a combat tour in the Marines before he decided that he really wanted to do medicine. And you would think that with all that going for him, that medical schools would welcome him, but it wasn't only UC Davis. It was all the medical schools that he applied to did not welcome him, and I think he thought, and I think he was right, that age had a lot to do with it.
And I guess I'd say one other thing, struck as I was reading the briefs to the Supreme Court in the Bakke case, that the university made a conscious decision not to go after Bakke in any way, shape, or form. They actually the California Supreme Court said, hey, maybe he wouldn't have gotten admitted anyway. Shouldn't we send it back? And the university said, no, we will stipulate, which means we'll concede he would have gotten in but for this affirmative action program. And I know in this day and age in which, frankly, so many people demonize the other side, I was very struck by the tone that the university took toward him at every turn, showing him respect, then saying, look, we have a principled reason for affirmative action, but, they didn't go after Alan Bakke.
By the same token, and you're going to see this in another clip that you're going to show, Alan Bakke did not use this platform to make some kind of issue or cause out of this for himself. He avoided the limelight during the entire litigation and every day since the litigation. And so that's something else that we don't see nowadays, where everybody wants to be famous, and being an important plaintiff in a big lawsuit would make you famous.
His first legal challenge was in Yolo County Superior Court, where he sued the Regents. And here's an article from that first lawsuit. And the decision, the judge there, Leslie Manker, found the school's program unconstitutional and in violation of Title VI, saying Bakke's admission needed to be reconsidered. The interesting thing is that both parties ended up appealing the decision, and I'm wondering how often that happens.
Yeah, so first of all, let me just explain. There was this Title VI issue in the case that you're averting to. So we've talked so far about, is affirmative action constitutional under the 14th Amendment to the Constitution? But there's also a federal statute that prohibits discrimination in universities that accept federal funds. And so sometimes some of these court decisions are talking about that statute, not the Constitution. Now, what happened here was something very unusual. The university actually said, this is so important to us, we don't really want to go to the California Intermediate Court, which is called the Court of Appeal in California. California Supreme Court, please take this case, let's bypass that. And there's a similar way to do that in the federal court system called certiorari before judgment. But it's used obviously in cases of extraordinary importance in which there needs to be a decision right away. And that's what the California Supreme Court did here.
And it was a 6-1 decision in favor of Mr. Bakke once again.
Right. And of course, one reason they wanted it expedited because the last case, DeFunis, had been mooted because they couldn't do it fast enough before the person graduated, and they already knew the Supreme Court was prepared to moot a case like this, and so let's get a move on.
So again, a headline from that Supreme Court decision in California, but then the school continued to pursue it. And then this goes to the point of how important they thought their policy was. And so talk about the jump from the California Supreme Court to the U.S. Supreme Court.
Right. So after the California Supreme Court decision came down, they had the option, do we ask the United States Supreme Court to hear it? Now, ordinarily, if you have a state court decision, the U.S. Supreme Court can't hear it because it's about state law issues, and the U.S. Supreme Court says, look, California courts, you know California law, we don't know California law, or whatever other state. But here, the California Supreme Court decided a federal issue, and because of that, the university was able to go and say, hey, Supreme Court, hear our case. And to do that, you have to file something called, it's got a long Latin term, petition for a writ of certiorari. That's, I, Supreme Court, am asking you to hear my case. And, today there are about 8,000, 9,000 of those petitions every year. The Supreme Court grants about 65 of them. So the odds are very low of getting your case heard before the Supreme Court. But obviously in a case of importance, that matters. And in a case in which the country is divided and the lower courts are divided, that can obviously help. So here that's what the university did. They filed a petition to say, hear our case. Now, what's interesting about the petition is it's not a petition that really tees up what we now think of as Bakke. What we now think of as Bakke is the diversity rationale, people learning from each other. But when you write a cert petition, you actually write, the very first page is the question presented. You're asking the Supreme Court to answer a question. And the question they said was the following: when only a small fraction of thousands of applicants can be admitted, does the Equal Protection Clause forbid a state university, professional law school faculty, from voluntarily seeking to counteract the effects of generations of pervasive discrimination against discrete and insular minorities by establishing a limited special admissions program that increases opportunities for well-qualified members of such racial and ethnic minorities. Now that's a handful. It's
sure
a long
is.
question.
Yeah.
But basically what it's saying at the end is, can we have affirmative action to remedy the societal effects of past discrimination? So we're making up for abuses at some earlier point in time. That's not affirmative action after Bakke. Afterwards, we're not trying to make something up, we're just trying to improve the diversity inside and outside the classroom.
So in a couple of minutes, we'll learn about the court that this case went to, but right now it's time for some of your phone calls. First is Glenn in Freeland, Michigan. Hi, Glenn, you are on the air.
Thank you all very much. I have a couple of fast questions. One is about state affirmative action programs here in Michigan, and actually California kind of led the way for us in a number of states to do this. We had a ballot initiative that got rid of race and gender preferences and that kind of stuff. It passed overwhelmingly, but it became the subject of a lawsuit that went all the way to the Supreme Court itself. It was decided in 2014, and the ban on race and gender preferences and that kind of stuff was upheld here. The ballot initiative we passed was upheld by a 6-2 vote. I think Sotomayor and Ginsburg were the only ones who voted against it. Anyway, my question is, I think if I remember right, they basically said affirmative action was constitutional but not a right. Some people have argued that it's a right. I've heard demonstrations, if that's anything to go by, where angry students have chanted affirmative action is our right and that kind of thing. So my first question is, would either of your guests argue or say that there's any legitimacy to that argument that affirmative action per se is a right? And my second question is about affirmative action on the federal level. A number of years ago, I remember there was a presidential candidate called Phil Graham, and one of his big campaign stump lines was the first thing he'd do when he took his hand off the Bible after he became president was sign an executive order to outlaw all federal affirmative action. Would it be that easy for President Trump or any president to get rid of affirmative action that way? Thanks very much.
Thank you.
Well, let me start with your first question, and then Randy, I'm sure has a lot of thoughts as well. So I actually was involved in that case, the Michigan case that you're talking about, and I thought your question was great. It totally summarized exactly the issue, which is you have in Michigan and in California state referenda that ban affirmative action in the university setting, and plaintiffs came in and said, we have a constitutional right. Affirmative action is constitutionally compelled, and you can't get rid of it. Now, as you'll hear, I'm a big believer in affirmative action in the university admissions context, but I thought that was a ridiculous argument. The idea that once you have affirmative action, it's there for all time, and it becomes some sort of embedded right that you can't take away even when there isn't a need for it, whatever. Any number of things can change. It's interesting, when Bakke was litigated, the fabulous former dean of the Harvard Law School, former Solicitor General Archibald Cox, ended the brief to the Supreme Court by disclaiming any of this, saying, look, I am not here to say affirmative action is constitutionally compelled. I'm here to say if a university decides with its leadership to have affirmative action, then absolutely it's within their constitutional right to do so, but it's also within their constitutional right not to have a program.
I don't really have that much to add to it.
How about his second one, on the federal level? Could a president just, with one...
Well, we're learning an awful lot these days, and Neil actually is the one who could tell us a lot more about how restrictive executive actions can be. Under the last administration, they seemed rather unrestricted, and now we're finding out that, wait a second, there's restrictions on what a president can do that we didn't hear about before. So actually, I'm just curious. I actually want to know from the horse's mouth what Neil thinks about restrictions on executive actions for that. I really don't know.
Well, I think I've applied the same standard myself, and I think many people have. Certainly, President Obama's executive actions were challenged every day of every week. So it's not like there's some new thing like, oh, we're challenging executive power. I think that's been challenged for a long period of time. But look, I think that the president would have latitude to get rid of affirmative action as long as it's done. It's not. There are many statutes that require it, and so if law of Congress requires it, that's one thing. But if it's a voluntary decision by one president to have affirmative action, I suspect that there will be ways for a future president to get rid of it. There may be some settled expectations in certain government contracts or something like that, transition issues. But otherwise, I would think a president would have such powers.
And that's an important point. I mean, that is that the question is, does a statute give the president the discretion the president is exercising when he issues an executive order? And if the statute doesn't, then that's a completely different situation.
Nathan is up next in Old Saybrook, Connecticut. Hi, Nathan.
Hi. Boy, I didn't expect that answer. Thank you, Susan, for this series. It's been very educational. A quick comment and then my question. My comment is that I personally support affirmative action because I think we would have had all-white police departments and all-male fire departments without it. Now, my question is, two of our presidents have been adamantly opposed to affirmative action. That was Ronald Reagan and George W. Bush. Has President Trump gone on record regarding affirmative action at all?
Not that I know of.
Not that I know of.
Sounds like not. Do you have another question besides that?
Nope, that's it.
Okay. All right. Thank you. Next is Raphael in New York City.
Great. This is my first time, so thank you very much. But I just wanted to tell you, to share some personal experience. My wife is a physician. She is from Queens, now from the Bronx, like the Sotomayor, but she's Latina. And I think that from my perspective, the affirmative action has enhanced the possibility of many minority families to become well off. I tell you that my wife became an obstetrician and gynecologist after going from Queens in 1975 to Dartmouth Medical School, a 3-year program they had there. She came in 1978 when Bakke came about, and she went to the St. Luke's Hospital where she trained as a OBGYN. We had 3 kids. Our first kid decided to become a doctor. But before doing so, he went to the Army, and he happened to be a Bronze Honor veteran. But right now, because of my wife becoming that doctor, that really motivated my son, that after going to war, fighting for America, and he came back, went to Columbia University, finished his program, then he went to New York and finished medical school. And presently, he is the psychiatrist in charge of the Air Force Academy in Denver, Colorado. So, in my final comment is that it does contribute to the betterment of a community in all its totality. So I'd just like to share this with you.
Thank you. Thanks for your call and for sharing your story.
Well, I love your family, and it's a love. My hat's off to your wife and to your son. One of the reasons your question's so great is it actually, picked up on exactly what happened at the oral argument in the case. So the University of California's lawyer, Archibald Cox, he began his argument with 3 facts, and let me read you his third fact. There is no racially blind method of selection which will enroll today more than a trickle of minority students in the nation's colleges and professions. So he's saying, look, we need affirmative action because otherwise we're going to have almost no one. And then he said almost exactly what you just said about your wife and your son. He said, quote, yes, it's possible for a black to go to the University of Minnesota or Harvard or Yale, once they see affirmative action. I know Johnny down the street, and I know Sammy's father. He became a lawyer, and John's father became a doctor. So it's this idea of role modeling, the idea that when you see other minorities that are successful, then you yourself may be more likely to enter professions that you thought were closed.
But what's interesting is that all of these benefits that have certainly accrued to some beneficiaries of affirmative action, and I don't know that we can really be sure that this caller's family really was benefited by affirmative action. They may have, like Justice Sotomayor, been admitted anyway. But all of these benefits are sort of irrelevant to the Bakke case, even though they did come up in oral argument, because they were not irrelevant to some of the judges. Some of the justices wanted to decide this case on the basis of that kind of benefit. Thurgood Marshall, first among them, wanted to do it. There were not 5 votes to do that. There were only 4 votes eventually to do something like that, and the 5th vote was diversity. We've already went through this at the top of the show. And so none of those justifications are the constitutionally accepted justifications for affirmative action. They are, as an educational, although they're not completely unmentioned in the opinion, but basically it's, does a school have an interest in having a diverse student body in order to enhance its educational program? And that's where this discussion of diversity has come from. The actual narrow Justice Powell opinion, which for a very long time was only Justice Powell's opinion, and now it represents a majority of the court.
Lewis in Fresno, California. You're up next. Hi.
Hi. Yeah, okay. I lived through 1978, and I had, even at that time, a 98th percentile in physics on the medical college admissions test. And in 1985, I retook the test, and I scored a 99.9 percentile in physics and 98 percentile in biology and mathematics and like subjects. But my question is, how did the case get to the U.S. Supreme Court when it was going to so adversely affect very deserving students throughout the entire nation? I had served in the Air Force, and later I served in the Army Reserve and the California Air National Guard. And I did my best, and I had friends from every possible race in the nation, and we were all treated equally. But when it came to test scoring, if you had the money to pay for Kaplan test centers, you could raise your scores to 99.9 percentile across the board. I would have done it if I had the money, but I was happy with 199.9 percentile in physics, and I would have gone beyond that if it hadn't been for Bakke winning what he won in the case. It was enough to affect all the undergraduates that were wanting to apply to medical school.
How did it? I don't understand
how did it affect them?
How did it affect him?
What happened? What happened to you? Did you go to medical school?
It was very discouraging. Yes, I did. I went to Puebla Medical School, which is in Mexico, which was very nice of them. But I couldn't be a communist, and that was what was being required at the time. Like I said, my uncles, many of my uncles, cousins, they had fought for the United States, and they had served in the United States military.
Okay.
And they...
Lewis, thanks. I'm going to jump in. Thank you very much for your own experience. I'm not sure if we can process anything there that will help us understand the case any better. Okay, well, let me move on then. Thank you for your call and having lived through that time and actually applied to medical school. So here's what the court looked like in 1978. And the newest justice was a Ford appointee, John Paul Stevens. Nixon appointees were the Chief Justice, Warren Burger, Harry Blackmun, Lewis Powell, and William Rehnquist. Earlier, Johnson appointees, Thurgood Marshall. The Kennedy appointee, Byron White, was still on the court. And still 2 Eisenhower appointees, William Brennan and Potter Stewart. This was the 9th year with Warren Burger as the Chief Justice. Is there anything notable about the Burger Court in terms of its racial decisions, things that involving the minorities in the country?
Well, as Neil already alluded to, President Nixon had made a number of appointments to the court by this time, including Warren Burger. And as a result, the political valence of the court substantially changed from the Warren Court, which was what we might call a progressive court, and to a more conservative court, but a court that was not sort of rigidly conservative. It was just a pullback or retrenchment from the Warren Court. So yeah, it is actually quite significant. I think we would associate the position of the 4 justices who were aligned with Justice Marshall in this case with what the Warren Court would have been expected to do. But because we are now in the Burger Court, that's not what we get. And we also don't get a complete abandonment of affirmative action either for this court. What we get is that middle ground that Justice Powell represented. That's sort of characteristic of the kind of middle ground you ultimately got from the Burger Court.
And I think when you think about the Supreme Court, when you study it, you think it's not, you can't just study one case, Bakke, and say, oh, snapshot 1978, and now I can figure it out by reading the briefs. You have to think about what is the court thinking about at the time. And this also goes to your question earlier about DeFunis, the 1974 case that they got rid of. The year before, the court decided something incredibly momentous, Roe versus Wade. And it was a 7-2 decision, and people took to the streets. And they obviously put their thumb on one side of that scale. So is it any surprise that the next year after Roe, they don't want to necessarily jump into affirmative action in such a hotbed way with the DeFunis case? Well, now 4 years have passed, Bakke, but still, I mean, the court is defined in the public eye by abortion and by really a strong decision. And so, you know, it's not all that surprising at the end of the day that the court lands in the Bakke case where they do, with a kind of middle-of-the-road compromise position. As Randy was saying, it's not one that gives all of the rationales of affirmative action about making up for societal discrimination or role models or anything like that. It's a much narrower rationale.
So you earlier told us about the writ of certiorari, and it's just commonly referred to as granting cert. So that's how we'll use it from this point forward. The University of California filed for cert in December of 1976, and we're going to return to the Library of Congress for a really interesting backstairs look at how the court works. This is a vote sheet from Harry Blackman's papers that talks about how they managed to get enough votes to move the case forward.
This document is a docket from the Harry Blackman papers. What this does is a couple of things. One, it tells you when the case was argued, when it was voted on, and when it was announced. Anytime you want a case to be heard by the Supreme Court, you have to file a cert memo. Often those memos are then reviewed by clerks who then kick their opinions onto the justice, who then makes a decision to vote yay or nay, to deny or grant the hearing. So you'll notice there's a 5-4 split to vote for certification. The liberal justices, particularly Brennan and Marshall, were worried that a negative decision, or what they perceived as a negative decision in this case, would not align with the jurisprudence that they believed was correct and just. Meaning, they worried that a negative opinion would diminish civil rights policies, hurt affirmative action, and really undermine what Marshall's main kind of worry was, that yes, you've passed laws to kind of address these injustices, but you haven't gotten at the underlying infrastructure that's created them and that reifies kind of what he saw as inequality. Whereas the conservative justices, who are more concerned with the kind of the liberty issue, they are all ready to hear this case because it does align with the jurisprudence that they believe is just.
So it actually was 3 times that the court considered before they had enough votes to grant the case cert and move it forward. What did you learn from that? Are you familiar with that wrangling that goes on behind the scenes?
Oh, yeah, absolutely. I mean, as a law clerk, you don't get to see it. You hear a little bit about it, and certainly as a litigant before the court, you are trying to understand that process as best you can from the outside. And, you know, what's very interesting about that tally sheet is normally today in the modern Supreme Court, the people who vote to grant to hear a case are the people who think the decision in the court below was wrong. Okay, so here the decision was in favor of Bakke, but the people who voted, according to the tally sheets you just saw, were actually the people who thought the decision below was right. And it was the liberals on the court who were acting defensively and saying, oh, we don't want to hear the University of California's petition. Don't hear it. Go away. Because if you hear it, then what's the law in California now might be the law nationwide, no affirmative action. It's a very interesting thing. It is the case that the court will often relist and discuss things at another conference so that it'll come up for rediscussion week after week. Indeed, now, for the last several years, the Supreme Court's moved to almost a rule that says you have to relist a case. It won't just decide to grant certiorari on day one when they hear a case.
One follow-up before your comment. And at the same time, civil rights organizations were really petitioning, urging the court not to take up the case for the very same reason. They were afraid that the outcome would be affirmative action policies turned over across the land. So how political is the court in that case? How influenced are they by outside pressure?
Well, I don't think it's right to think of the court as political. I mean, once you get on the court, and this is true for justices appointed by Republican presidents and Democratic presidents, they are justices, and they will vote against their president. Rehnquist was put on the court by Nixon, but voted against Nixon. Kagan was put on the court by Obama, but voted against part of Obama's health care plan. So there's all sorts of examples of this. Breyer voting against Clinton in the Paula Jones case, and so on. So I don't think they're political in that sense, if that's what you mean. I do think that they do think about, should we get into a case? Is the country ready for a decision? Have all of the issues been adequately ventilated in the lower courts? And is this the right time to decide something momentous?
I mean, here's something that hasn't come out yet. It takes 4 votes to grant cert, but it takes 5 votes to win the case. So 4 justices who could actually get the court to hear the case if they want to, they have to be able to count to 5, or they're not going to vote for cert. And I think the problem here for the liberal justices, they had maybe a hard time figuring out how they were going to get to 5, and therefore they didn't want to hear the case. We had the same thing happen with the Second Amendment right to keep and bear arms. The NRA did not want that case to go to the Supreme Court because they weren't sure that they could get an outcome that they wanted, and they didn't want to have a bad outcome that would then be national. And so they tried to undercut challenges to the court, including the Heller case, as best they could, and it was actually an independent group of people associated with the Cato Institute. It wasn't the Cato Institute that did it, but people who were associated with the Cato Institute and other libertarians who brought that suit over the objection of the NRA, who actually tried to subvert it precisely for the same reason. They were afraid of an adverse ruling that would then nationalize a bad rule on the Second Amendment.
So we're going to listen to some of the oral arguments. First, a reminder of what in a boiled-down fashion, what the 2 major questions were before the court. First of all, is race-based affirmative action constitutional? And secondly, is the University of California's quota-based affirmative action constitutional? So let's hear Archibald Cox's arguments. These were held on October 12, 1977, and there were 2 hours of arguments, which is a little bit longer than usual. Normally now it's 1. Do we know why there were 2 hours in this particular case?
Sometimes they'll expand argument. I've certainly had that happen in major cases in which they want more. And here we knew there were going to be 3 litigants, not 2, because of the United States Solicitor General, who appears in 1/3 of all arguments. But this was a particularly important one.
Who was Archibald Cox?
Well, Archibald Cox was a famous Harvard law professor. He actually, after he retired, joined the faculty as an emeritus at Boston University. His office was next to mine when I was on the faculty of Boston University, so I heard that voice occasionally coming from his office. So he was very well known, and he's best known to the general public for having been the special prosecutor who was appointed to investigate Watergate and eventually was fired by Robert Bork, as a matter of fact, when President Nixon was opposing Cox's use of a subpoena to try to get the Watergate tapes, the famous tapes that the Nixon administration that Nixon himself had made. And then he was eventually replaced by Leon Jaworski, a different special prosecutor. But that made Archibald Cox, who was at that point, somewhat obscure Harvard law professor, to the general public, a household name.
And he might become a household name again.
We're going to listen in as he makes some of his arguments before the court in Regents versus Bakke.
The objective that impresses itself on my mind, partly because Dean Lowry testified it, partly because I am, at least in part, an educator, is the importance of including young men and women at both undergraduate colleges and the medical schools so that other younger boys and girls may see, yes, it is possible for a black to go to University of Minnesota or to go to Harvard or Yale. This is essential if we are ever going to give true equality in a factual sense to people, because the existence or non-existence of opportunities, surely we all know, shapes people's aspirations when they're very young.
Mr. Cox, what if Davis Medical School had decided that since the population of doctors among the minority population of doctors in California was so small, instead of setting aside 16 seats for minority doctors, they would set aside 50 seats until that balance were redressed and the minority population of doctors equaled that of the population as a whole? Would that be any more infirm than the program that Davis has?
Well, I think my answer is this. There is no reason to condemn a program because of the particular number chosen.
Randy Barnett, what do you think of his argument?
Well, I like that. I think my answer is this. It sounded like he was thinking about what his answer was when he said that, actually. And also was struck by the argument. I actually listened to the whole argument in preparation for this show, and I was struck by how the justices let him talk without interruption for great expanses of time. They treated him the way the Solicitor General is often treated in oral argument.
Not anymore.
Very deferentially, as opposed to his opponent, who was actually peppered quite very heavily with questions. So he got to, you heard that long excerpt. Well, that's a long excerpt. You don't hear that much anymore. At the beginning or the end of argument even, you don't hear any advocate in almost any contested case get that much time to speak.
Yeah, and I guess I'd say two things about that. Number one, the reason why that is not anything about affirmative action. It's all because of one guy we were talking about earlier, Antonin Scalia. Your public can listen to any oral argument on oyez.org, oyez.org, and you can just type in Brown or whatever case you want to listen to. And after 1986, when Justice Scalia gets on the court, oral argument becomes a very different thing. Before that, you could go up with, almost a speech or something like that. Now I go up with like one line on a legal pad and hope I get that one line out before I get my first question. That's the first thing. The second is, you heard then Justice Rehnquist ask that question to Mr. Cox, and Rehnquist was a fabulous questioner, just phenomenal. And, that question typifies a lot of Supreme Court argument, which is, the justices are trying to say, okay, I've read your brief, but how far does the logic of your position extend to? And so they come up with hypotheticals like, okay, it's not 16 out of 50 seats, it's 50 out of 50 seats. Does your argument still hold? Why not? What are the logical limits to your position? And that's really what the art of Supreme Court advocacy is all about.
And Cox was reading that speech, and I know that because at some point he skipped a line, and then it threw him off, and he had to go back and get that line up. And so I know that he read that speech.
So here is a bit of the other side. Ronald Colvin was a San Francisco attorney who argued on behalf of Alan Bakke, the only case that he argued before the Supreme Court. Let's listen.
So part of your submission is, even if these are compelling interests, even if there's no alternative, use of the racial classification is unconstitutional.
We believe that it's unconstitutional. We do.
Is that because it's limited rigidly to 16?
No, not because it's limited to 16, but because the concept of race itself as a classification becomes, in our history and in our understanding, an unjust and improper basis upon which to judge people. We do not believe that intelligence, that achievement, that ability are measured by skin pigmentation or by the last surname of an individual, whether or not it sounds Spanish.
Well, do you mean by that as to the 16 places, the allocation was dominantly by race?
Oh, there's no question but what the 16 places was dominantly by race. And I have to go back to the record, if I may, just to reach that point. There were no non-minority people who were ever admitted to the special admission program. And I do not mean that that was for the lack of trying.
So, Neil Katyal, what do you hear there?
Well, it's always tough to argue before the Supreme Court, and it's particularly tough if it's your first time, as it was for Mr. Colvin. I do want to say, I'm joined by a person on this panel who, in his first argument, did a magnificent job, and everyone should listen to it. It's a rare think, to do it, pull it off in your first time. So my sympathies go out to Mr. Colvin, because the whole argument, really, I think, didn't go the way that he kind of hoped it would.
He won the case.
Well, won it in a way, yes, yes, but I don't think it was because of the argument at the end of the day, as the tally sheet shows from the votes on certiorari before the argument. So, I do hear, I think all through the litigation, the strategy of Bakke was to say, this is a quota. There are 16 slots that no one else can get except minorities. And that was a powerful argument, and that was probably his best moment in the argument, which you just heard, and harping on that.
And we also heard that there was another argument from the Solicitor General, who happened to be an African American himself, Wade McCree, offering arguments on behalf of the Carter administration because of the national interest the administration saw in the case. And the brief, if you look in the archives, had lots of input from members of the Carter administration as they prepared for the court. A couple more calls, and then we'll move on to the decision. Ted in Oak Park, Illinois. Hi, Ted.
Hi, thank you. This is great timing on the program here. We just discussed this in my high school African American Studies class today. And my question has to do with the diversity rationale. Was the diversity that was accepted as a rationale only race diversity, or could it be gender diversity or political diversity? And secondly, at the time or since, has there been any meaningful research as to whether diversity actually gives superior educational outcomes, or is it just a plausible intuition? Thank you.
Thank you.
On the first question, the issue here was whether, for some reason, everybody agrees that with admissions to higher education, diversity is important. Everybody always agreed with that. Although diversity early on was used as a way of excluding Jews from the Ivy League schools because too many Jews were getting in on merit, and therefore the school went for geographical diversity in order to get some more Iowa people in who were not Jewish. But no, the issue here in this case is whether race is taken off the table, not whether other things can be added in, but whether race is taken off the table such that Alan Bakke was discriminated against because of his race. And so under the Equal Protection Clause, the issue was, is race a no-no, not whether other things could be used as pluses. And
what was so interesting about the litigation strategy by the university in the case is that they didn't emphasize diversity at all. In fact, you have to go to page 54 of their brief before they actually mention diversity, and it's only like not even a full sentence about it. But nonetheless, as I know we'll talk about in a bit, diversity became the rationale for the controlling opinion by Justice Powell. And to answer the caller's question, Justice Powell said, it can't just be racial or ethnic diversity. You've got to consider diversity among a whole variety of different forms, as you were talking about political or geographic or socioeconomic. It can't just be isolate out one race and think that that's going to be sufficient.
Can I just say one thing about Colvin's argument and his success? He starts his argument off by saying, I am here, I represent this man, he wants to get into medical school. Well, you know what? He got into medical school, and he said quotas are bad and off the table, and you know what? He won on that point too. So as ineffective as I think we both think he was as an advocate, he got the two things he was going for.
Lewis, Henderson, Nevada, you're on the air. Hi, Lewis. Go ahead, please. All right, sir. Sorry, we're going to move on to Adrian in the Bronx. You're on.
Yes, I'm interested to find out why. I understand that Bakke was not. He was contesting about being admitted to because of his medical school. But why wasn't the point made about age discrimination? Because it seemed to be more of an issue. He was rejected because of his age, which is what they had contended. So I was wondering why wasn't a point made for age discrimination.
Okay, thanks. We talked about that earlier, but she wasn't with us.
As we said earlier, age discrimination at this point in history had not been considered either a constitutionally permissible basis of a challenge or a statutorily permissible basis. And it wasn't until the Age Discrimination Act was passed, and I don't remember exactly when that was, but I think it was under the first Bush, that this became a statutory remedy under U.S. law.
And Lewis in Philadelphia, you're on the air. Hello, Lewis. Go ahead, please. All right, we're going to move on. Sorry about that. When we call you, I know you're listening to the screen, but be ready to go with your question, please. So we're going to learn about the next part of it, which is getting to a majority. And we're going to return to the Library of Congress, Ryan Reff, with papers showing Justice Powell's difficulty in getting to a majority.
This is from our William J. Brennan papers. He was seen as Marshall's kind of liberal ally, and they worked together often. This is part of a larger 40-page memo written to his clerks for typing up later, in which he discusses the various avenues and curves of the deliberations in this case, and particularly the fact that Marshall was particularly offended by Lewis Powell's draft opinion. From Marshall's point of view, it failed to acknowledge these larger structural inequalities that have been established, and that yes, you can pass laws in 64 and 65 opening up civil rights, but if all you're doing is passing those laws and not changing the underlying structure, then you're reifying or kind of reasserting the same kind of structural inequalities that had negated African American progress. Now for Justice Powell, if you turn to this letter that he wrote on June 27, 1978, one day before they announced his opinion, this letter is an attempt to try and cobble together one or two more opinions onto his side. I think he knows that it's unlikely to work out, particularly at this 11th hour as he's kind of putting out this memo. He ends the memo, quote, "As I am a chief with no Indians, I should be in the rear rank, not up front." And that's what happened. And yet, ironically, Powell's opinion, despite the fact it really had no other fully co-signed justices on it, is the one that persists for the rest of the century.
And so we're going to look at how that decision turned out. It was, in fact, split on the two questions. Affirmative action is constitutional was a majority of Justices Powell, Brennan, White, Marshall, and Blackmun. And on the question of whether or not the UC Davis program was constitutional, the answer no. Powell, Berger, Stewart, Rehnquist, and Stevens. There were also 5 concurrences and dissents. And so it was a very complicated real outcome. I want to go through this because our time's getting short and put some of the excerpts, and then we can talk about what it all means. First of all, on question 1, is race-based affirmative action constitutional? This was a 5-4 regarding that question. And here is an excerpt from Justice Powell's majority opinion. The court today affirms the constitutional power of federal and state governments to act affirmatively to achieve equal opportunity for all. Government may take race into account when it acts not to demean or insult any racial group, but to remedy disadvantages cast on minorities by past racial prejudice. And here is Stevens' dissent excerpt signed onto by Berger, Stewart, and Rehnquist. It is therefore perfectly clear that the question whether race can ever be used as a factor in an admissions decision is not an issue in this case, and that discussion of that issue is inappropriate. The meaning of the Title VI ban on exclusion is crystal clear. Race cannot be the basis of excluding anyone from a federally funded program. Okay, let's talk about the opinions on that question. What should people take away from that?
Well, there were 2 issues in the case. The principal one was the constitutional issue, but there was always the statutory issue as well. And there were some justices, and it turns out to be 4 justices, who would prefer to have decided this case on statutory grounds, on Title VI grounds, than on the constitutional grounds. There was some issue as to whether there was even whether an individual could assert a cause of action under Title VI that bothered some of the justices. I think it was Potter Stewart that it bothered the most. At any rate, as you say, the court eventually decided, Justice Powell, siding with the 4 more liberal justices, did reach the constitutional question, and affirmative action was upheld, but it was upheld in a way that would have to avoid quotas, whatever that might be. And that was the dance that we've been engaged in ever since then. When is something a quota, and when is it a goal or something other than a quota? It's this case that put us into that situation.
Yeah, maybe to just back up a little bit and just talk about, so there are 9 justices on the court. And, at the end of an oral argument, like a day or 2 later, the 9 will go meet in a conference room, and no one else will be there except the 9 justices. And they will go around the table and say how they tentatively vote in a case. And ordinarily, it's a decision that is, some people in the majority and some in the dissent. Sometimes you're unanimous, and, oftentimes, in which they all agree. But sometimes with a 9-member body, you get these weird things happen in which you've got, like this case, you've got 4 justices, affirmative action violates the statute. 4 justices, affirmative action's totally cool. 1 justice saying, well, it's only kind of cool. It's that 1 justice's opinion that actually controls the court, because it's the narrowest ground of decision on which on which a majority of the court agrees. And so here, that narrow decision, narrow rationale, was by Justice Powell. And yes, he only got 1 vote, but boy, was it an influential vote. Because sometimes you're the only justice, but if you say something right, it ultimately takes off. Justice Scalia did it in the Independent Counsel Act. Justice Rehnquist did it on federalism issues in the 1970s. And here you've got Powell doing it here. He said something that spoke to the lived experience in universities, and administrators picked up on that and understood what it meant.
There is one little twist on the story here, and that is Justice Blackmun was having prostate surgery at the Mayo Clinic in Minnesota, and so he wasn't present for the first conference, and they didn't really know how this case was going to come out until he got back, and then they were able to get him to give an opinion. And even in the beginning, when he got back, he didn't want to give them an opinion, and finally I think it was the Chief Justice who had to go into his chambers and said, "Are you ready to tell us how you're going to vote yet?" And he said, "Not yet." And then eventually he did, and then to the surprise of some members of the court, he actually did side at that point with the liberal side of the court.
Let's move on to the second question, which is about the University of California's quota-based affirmative action system, finding that it was not constitutional. It was a 5-4 decision again. And here is an excerpt from Justice Powell's majority opinion in question 2. The special admissions program is undeniably a classification based on race and ethnic background. The guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. And from Justice Marshall's dissent on this question, he writes, "It is more than a little ironic that after several hundred years of class-based discrimination against Negroes, the court is unwilling to hold that a class-based remedy for that discrimination is permissible." Comments?
Yeah, so this quota, this kind of remedial view of affirmative action does not command a majority of the court, despite Justice Marshall's passion on the issue. And so as a result, Justice Powell's opinion, which says no quotas, but you can engage in diversity-based affirmative action, which looks at the whole person and allows every person to compete for every slot. That's okay. What was wrong with the University of California system was that it told people 16 out of 100 slots, you can't apply if you're Caucasian. You don't get to even a chance at those. And that, Justice Powell said, was wrong, and I think that's where the heart of the country was and is today.
Justice Marshall's view that you just quoted from us represents one side of the 2 different versions of discrimination and race that separate the court even today. And this is the way I teach the court, these sets of cases. On the one hand, you have Justice Marshall and the liberals today on the court who say what's banned by the 14th Amendment is what they call invidious discrimination. Discrimination that is actually aimed at demeaning or undermining or subordinating one group of people. And what's not banned by the 14th Amendment is what you might call benign discrimination, discrimination intended to help. The difference between what Justice Stevens would later call a no trespass sign and a welcome mat. On the other side of the court, represented by Justice Thomas, and it was then Justice Scalia, is the view that reuse of race is in classifications other than to remedy a violation perpetrated by the party before the court, like the University of California had a history of this. The use of race is so insidious that it should simply not be used as a classification at all. And even if you think you're using it benignly, you may not actually be using it benignly. And that is the divide that separated the court then, and it's the divide, I think, that separates the court today.
Here's a comment from Mari Lane on Twitter. When the interpretation of the 14th Amendment is overly broad, it operates against those who suffered past harms and abuses. It was intended as a remedy in the Reconstruction Amendments for race-based enslavement. Let's listen to what the students and the university community, how they reacted. This is from a CBS documentary on the Bakke case.
I consider it a victory, not only for the University of California, I consider it a victory for minorities and for social justice and for higher education.
But others disagreed. Several minority students presently enrolled at the Davis Medical School called the ruling a slap in the face, saying the struggle for equal rights was being undermined.
The question arises that if it took you 200 years to build a house and somebody came along with a match to burn that house down, how would you feel about the person?
Robert Friedland, another med student, said he felt pretty good.
Well, I'm pleased because it struck down a program which I feel has very questionable criteria involved, that it was explicitly preventing white students from applying through the program.
And we'll look at what some of the national reporting on it. For Los Angeles Times, one of the major papers in the country, Bakke wins, but justices uphold affirmative action. What was happening in the country when this, were people on the edge of their seats waiting for this decision to come out? Was it seen as that important at the time?
It was one of the first really big hot-button issues. In some respects, I think it was bigger than Roe versus Wade. At the time Roe was argued. Abortion became a big hot-button political issue after Roe versus Wade, in part as a result of that decision, but it didn't build up to that decision. This is an issue that was teed up in the DeFunis case, so everybody got teased, and they were ready for a big decision then. They were disappointed, and now they're going to get it, and it was a subject of huge controversy. This was perhaps, at this point in history, the most publicly debated and protested outside the Supreme Court decision that had happened up until that point.
In our final segment, we're going to look at the legacy of the case, but time for some more calls. First is Josh, Algona, Iowa. And Josh, as we begin here, I think we've had you with us throughout the whole series of 12 cases. It's been great to have you in the audience. What's your question about tonight's case?
Thank you very much, Susan. My question tonight is about Thurgood Marshall and just how influential he was in this decision and how influential he was on the Supreme Court in general.
So, on this decision, he obviously lost. The remedial kind of broad view of affirmative action didn't, I think, prevail. And Justice Marshall, I think, as a justice, maybe wasn't as successful as some of the others. Now, there's any number of reasons why that could be, including the fact that, President Nixon had so many appointments, as did President Reagan. So there's, I think a bunch of things that are going into that. But I think it's fair to say that, his legacy as a justice was not quite the legacy of a litigator, although that is pretty much a totally unfair standard, since you are talking about, if not the greatest litigator in United States history, the second greatest litigator.
And in this case, Justice Marshall greatly influenced Justice Brennan on this question. And then it was Justice Brennan who did the politicking to make it, and it took a lot of work on Justice Brennan's part to get the 4-vote to become the 4-vote block. And he did that, in a sense, for Thurgood, because that's how they refer to each other. So Justice Marshall's influence was felt in this case as well.
Michael in San Diego, you're on the air.
Yes. I was a student at UCSD in 1975. I was a medical corpsman in the U.S. Navy with the Marines. I was overseas. I fought for this country. And when I came back, I wanted to pursue medicine as a career, and I was denied. I strongly stress to you, I was denied my right that I fought for to go ahead and become a physician. I will be retiring from a school district next year. I have 12 more classes of law school, and then I will go ahead and practice law at age 72, 73, because I was denied my right to go to medical school. Now, what has transpired today that would not happen to the Iraqi and Afghan veterans, such as myself at Vietnam? What would be different today?
So I love the question because it does really highlight the passion and the stakes that are at issue in something like this. And it also highlights, I think, why the Bakke decision was so powerful, because it said to people like this, brave caller who's called in, we're not going to have quotas anymore. You can apply for every one of those seats. And obviously you can have veterans preferences and any number of other things, diversity preferences for where you come from and socioeconomics and so on. But we will never tell you that you are not eligible for one seat just because of the color of your skin. And it's for that reason, it was a widely celebrated decision. I mean, just to read you a couple of headlines, the Wall Street Journal, right after Bakke, called it, quote, the decision which everybody won. And the New York Times said it was, quote, the majority decision appeared to please a broad spectrum of people on both sides of the issue. And so, I think that's the needle Justice Powell threaded for the court.
So well, let's move on to what happened to Alan Bakke. First of all, we're going to play a clip that answers some of that question and then talk more about what happened in his life.
The public knows little about him, and that's because Alan Bakke wants to remain as unknown as possible. In what is believed to be his first interview ever, we spoke today about the decision and about his penchant for privacy.
I'm pleased with the decision, and that's all I intend to comment about it.
Why haven't you spoken out before?
It's my personal preference to not to speak publicly about the case. I like to keep my private life private.
Oh, but it's not a private matter when it goes to the U.S. Supreme Court.
My own personal life is private, and I intend to keep it that way.
Do you plan to go to medical school?
Yes, I do plan to go in the fall.
One other note, an update from the University of California at Davis. 97 medical students graduated there today, among them Alan Bakke, who made headlines in the 70s by challenging the university's racial quota system. Bakke had charged he was denied admission in favor of minority students who scored lower on entrance exams. Ultimately, the Supreme Court, in a landmark decision, ruled in his favor. Dr. Bakke began serving his residency at the Mayo Clinic in July.
And as we heard, he became a doctor, did both a residency and a fellowship at the Mayo Clinic. Dr. Bakke worked for many years, the rest of his career, as an anesthesiologist in Minnesota. Retired about a decade ago and then moved on to medical devices as a business venture. And I'll tell you that his hesitancy to talk continues to this day. We worked very hard to get him to give us one interview for the record about what it's like to be an individual citizen appealing to the Supreme Court. He very kindly said he was going to retain his aspect of his privacy in this case. Now, one of the things I wanted to ask you both about, I should add one other thing. In a later case, the University of California paid him more than $100,000 in his legal expenses. Throughout both Series 1 and Series 2, there are these wonderful examples of everyday citizens who use our system to get their case heard before the court. As we kind of close out this series, would you both talk about our system and how it allows for redress of grievances for people without special privilege among us?
Well, it does, and it does so a lot today because you can actually get a lot of free representation if you have a constitutional challenge that other people are prepared to support. My client, Angel Raich, in the medical marijuana case that led to Gonzalez versus Raich, took the exact opposite approach to Alan Bakke. I really admire Mr. Bakke's or Dr. Bakke's refusal to let his private life become a matter of public record. I think this is quite admirable. I also think it's admirable that Angel used the platform of our lawsuit to make medical marijuana a national issue. When I first started litigating in that area at the late 90s, it was considered a crank and crazy and fringe issue. I can tell you, because when I told people what I was doing, they said that to me. By the time we had a decision in the Supreme Court in 2005, it was a relatively mainstream position, and much to my surprise, more states continue to recognize medical marijuana, in part because of the legitimacy that our case gave that issue, and in large part because of the effort that Angel Raich did. She used that platform to do television show after television show, interview after interview, to raise the profile of that issue and really changed the politics of medical marijuana in this country. That's what one person was able to do in a single lawsuit.
And I have a very similar story. My very first argument was a case, a Guantanamo case, in which I represented bin Laden's driver. And I was sitting in the courtroom on June 28, 2006, hearing the decision come down with the Guantanamo tribunals were unconstitutional, the Geneva Conventions applied to the war on terror. We had won big things. We walked out to the press. There's 500 cameras on the Supreme Court Plaza saying, what does the decision mean? What does the decision mean? And here's what I said. It's almost verbatim. What I said is, here's what happened today. You had a man who was the lowest of the low, accused of being bin Laden's driver, and he sued not just anyone, he sued the nation's most powerful man, the world's most powerful man, the President of the United States, and he won. That's something great about our system. In many other countries, this driver would have been shot for bringing his case to the court, and more to the point for me, his lawyer would have been. But That's what makes America special. Our founders laced in checks and balances. They said, doesn't matter if you're the little guy. You can go after the big guy in a court, and if you've got a good argument, you can win.
So let's listen to Mark in Sanford, Maine. Hi, Mark, your question.
Yes, hi. Good evening. I just had I read the case brief, and I was impressed with the split decision, and I kind of understood it. But Mr. Bakke, I think he got his point across, so they agreed with him because his scores were higher than any of the minority students that were picked. So I think it worked out for the best. And as far as the affirmative action goes, I was wondering if the Attorney Katyal and the other lawyer from Georgetown could explain to me the difference between public school and private. Well, where state action would be for the public, right, and private would be.
Go ahead.
You wouldn't have the constitutional provisions.
Thanks,
Could you
Mark.
explain a little bit about the differences?
Sure, thank you.
It's a great question. So in general, the Constitution does not bind private individuals, private actors. You need to be what's called a state actor. There are a couple exceptions like slavery, but for the most part, that's what it is. So no matter how discriminatory I am as a private citizen, I can't violate the Equal Protection Clause. But I can violate Title VI, that other pesky statute we were talking about earlier in the Bakke case, which says if you're a recipient of federal funds, you're bound by certain equality guarantees, which the Supreme Court in the Bakke case said are just like the equal protection ones. And so for that reason, it does bind private actors too.
So let's move on to later developments and affirmative action and questions in the United States. First of all, California was back at it again with a proposition directly to the voters in 1996, California Proposition 209, and the outcome of that by a vote of 54 to 45 disallowed race being considered in state university admission, so underscoring the decision of the Supreme Court with the public. And let's move on to the Supreme Court and cases. Mr. Putnam, who's on Twitter, asked, how does the opinion issued in the Bakke case play a role in future affirmative action cases such as the University of Michigan cases? And here's a full list. There was, in 2003, 2 cases, Grutter v. Bollinger and Gratz v. Bollinger. Then in 2014, Schutte versus Coalition to Defend Affirmative Action, Fisher versus University of Texas in 2013, and another Fisher case in 2016. So we're going to have to wrap them all up into one. And why don't we start with you, Randy, to know what the court's been doing on
this.
Right,
but for purposes of this particular show, it's Grutter and Gratz that are the most important, because that's when Justice Powell's rationale became the majority rationale. Up until this point, for all those years, between 77 and 2003, it was one justice's opinion that all the lower courts were following. But 5 justices adopted the diversity rationale in Grutter and Gratz, and so then it became the majority view. So that, historically, with respect to Bakke, is where Justice Powell becomes the majority view, and it's why we're still talking about diversity today, and we're not talking about the other rationales that Bakke had eliminated.
Yeah, and I agree with that. I'm a lawyer in every single one of those cases, so I know them all intimately, and I think it's fair to say that in all of them, the litigation strategy was Justice Powell, Justice Powell, Justice Powell, that he had really forged a kind of really smart way of thinking about this that captured and resonated what university administrators, their lived experience had been. And so Randy's absolutely right. By the time of Grutter, the Michigan Law School case, diversity becomes the rationale. But the question was, is that going to survive Justice Kennedy, who hadn't ever voted for any sort of affirmative action until just recently in this Fisher versus University of Texas case, where he too sides with Justice Powell's opinion, and did it, fairly late in his career after he'd been on the bench a couple of decades, but nonetheless has also embraced the same rationale.
There's a case working its way through the courts, Students for Fair Admissions and Harvard. Is that possibly a case that he might have a chance to vote on?
I think I'm not going to talk about that one. Maybe Randy, do you want to talk about it?
Well, it's a case in which Asian Americans are challenging the admissions decisions, the admissions process in Harvard, and I think there's another case involving North Carolina, perhaps. And the issue here is whether Asian Americans are actually being discriminated against by the affirmative action programs that are benefiting other minorities. And it's very interesting because it's one thing to look at Alan Bakke and say, well, you're a white male and so you can't be discriminated against, but there's a good reason to believe that Asians are significantly underrepresented, and they're underrepresented perhaps by design the way Jews were underrepresented by design by the Ivy Leagues when diversity was first invented as a justification for a kind of discrimination.
So there's this dichotomy of the court versus society and who influences whom. I want to put a fairly recent public opinion question from Gallup in 2016 on university-based affirmative action on the screen. 70% of respondents said colleges should admit on merit alone, and 26% say race or ethnicity should be considered to boost student diversity. There's the diversity word. And we also had that caller early on that asked about the Trump administration. And our producer, Nate Hurst, researched the president himself has not spoken directly about affirmative action, but you might remember headlines from the Justice Department that they have, and here's a New York Times article, Justice Department to take on affirmative action in college admissions and looking for reverse discrimination examples that they might press on in the future.
But what I'd say about that is it's such a false dichotomy, a way a survey says, oh, take on merit or consider race. I mean, the whole point of what Justice Powell, his genius, was to say race is part of merit. You know, as a law professor, I've taught, you know, in situations where there are no minorities in the classroom. How do you teach the Bernie Getz case? I mean, it's tough, and, you know, or things like that, you know. So the idea that diversity matters to the educational experience, and it's not just race, it's politics, it's religion, it's geography. The universities that do that and take that mission seriously are better universities.
But here's the problem. The problem is that diversity in sometimes is just being used as a justification for helping out folks that they think are going to be more in agreement with them. I would be much more impressed if more schools of higher education put a premium on intellectual diversity, in addition to other forms of diversity than are currently the place that is currently taking place, where you have schools that don't take the view that Neil did when he was chair of the appointments committee at Georgetown, that intellectual and political diversity are important, and to the contrary. In fact, there's increasing levels of discrimination against people on the basis of viewpoint. So if diversity really is the rationale for taking race into account, then it ought to be the rationale for taking viewpoint into account as well. And I'm sad to say that largely it isn't.
Here's a comment from a viewer named Kay Brooks, who writes, Bakke decision was unfortunate, to say the least. As a white woman from a working class background, I was able to earn 2 graduate degrees due to affirmative action. Need more justices like Sonia Sotomayor who understand how hard some of us out here have to work just to get to the starting line. What would you say to that viewer?
Well, of course, that's absolutely right, and that's one of the reasons. That's the argument on behalf of affirmative action, and then you have the argument from the previous caller that we heard, who served his country and who got the test scores that he got, and he was not able to attend medical school. So this is there's a problem here, and it was actually highlighted in the Bakke case itself. There were many, many more people who were applying for medical and law schools back in that day than there were spots. And now you have to allocate a scarce resource, and somebody gets to go and somebody doesn't.
And I agree with, you know, part of what Randy is saying here, but the idea that because there have been some mistakes in some universities means we should take this incredibly important tool off the table and to say federal courts are empowered to take it away from universities, I think is so pernicious and damaging to our educational system. I mean, when you have university after university across the country saying we need this for an effective classroom and learning experience, when you have our U.S. military saying it, when you have all of our corporate leaders, our CEOs saying it, I think, you know, the courts need to stand up and listen to that, as they have.
Marcello, New York City, you're on. Welcome.
Hi, great. Thank you. This is a very high honor to be able to call in for the final program. I just have a really quick comment. How is it that it hasn't been mentioned yet in this case that the biggest recipients of affirmative action are actually white women? So that's what I want to ask. And another thing, where does Bakke stand in the constellation of affirmative action cases, decisions? Was Grutter, overruled it, or, where does it stand? Thank you.
Thank you.
Well, one of the problems that this whole area has going forward is the notion of majority versus minority, because we have a country in which white males are not the majority in the country. Females are actually outnumber males. And the more diverse the country becomes demographically, the more difficult it's going to be to say exactly who is the majority and who isn't. And then once you have decided that everybody gets a preference because everybody's a minority, then nobody gets a preference. And so this is I think, something that's going to have to be wrestled with in the future. Trying to superimpose our past, where we had decades and decades, centuries of oppression on the basis of race, where a particular group was actually singled out for enslavement and then legal subordination for another 100 years, is not necessarily the same as the types of obstacles that many people are facing today, who are one kind of minority or another.
Maybe to that end, Jude asks on Twitter, when does affirmative action end?
Yeah, I mean, Justice O'Connor in 2003 said, well, maybe it'll end in a quarter century. And, you know, I think it ends when the rationale for it goes away. And here you've got, I think, you know, a tremendous record that the University of Texas just put to the Supreme Court a couple of years ago saying, not now. Right now, we really, really need it, because otherwise, without it, we have, as was adverted to in California, when you had that proposition, the universities of California became far, far more white and far less minority in them. And so, look, you know, Bakke's a complicated decision, and these things have really hard stakes on both sides, emotional stakes, as we've heard from your callers today. But Justice Powell said, you know, sometimes the best decision is a compromise decision, not the extreme on either side. And, you know, in our country that's so divided right now, I think Justice Powell's kind of just method of listening to both sides and trying to come up with something that gives everyone something was, I think, a really instructive lesson for us all.
So we're just about out of time. I want to thank both of you for being at the table, two terrific guests to end our series, Landmark Cases, and thanks for helping us understand this complex decision and really how our society continues to grapple with this.
Thank you, Susan.
Thanks. As we've been telling you, this is our final of 12 cases for this season of Landmark Cases, so a couple of thank yous, if you'll permit me, at the end. First of all, veteran Supreme Court reporter Tony Morrow, who wrote the companion book with the 12 cases outlined for this series, as he did for Season 1. And then also the folks at the National Constitution Center, who are our partners in this series. You see the people who helped research the cases and many of the guests, along there with the president of the Constitution Center, Jeff Rosen, who was himself a guest on one of our earlier programs. And finally, let me show you all the people that are behind the camera. It takes a lot of us to put this television program together. And there you see our team for Landmark Cases, both the technical and the editorial team. Greg Sizowitz is our studio head, and all the folks who work with him on the technical side, Terry Murphy, Ben O'Connell, and Nate Hurst, leading and Yvette, who has been answering all your phone calls all this season, and making this all work for us. Thanks to everyone for your help in putting this together, and to our great viewers for all your questions by Twitter and phone call. Thanks for being with us this season.
C-SPAN's original series